Okay. So there is entirely like one topic on UB just EB Remedium. Okay. Now, when we talk about rights and duties, what is a right? Right is nothing but like entitlements, right? If you say you have a right to enjoy a certain property, as in you are entitled to enjoy the property, you can sell it, gift it, live there, whatever you want to do.
Yes, ma'am.
When you have not studied jurisprudence yet, right?
Yes, I have studied, but not in deep. I think first, like briefly, I've read, not in deep.
So in jurisprudence, you get a concept called rights and duties. Okay, when we talk about rights, it's not that rights simply exist of its own. There has to be a duty also. Okay, it's said that rights and duties are like two sides of the same coin. Like one coin cannot have only one side. If you are having a right, someone else has to have a duty as well. Okay, so rights and duties are correlated. Both the things will exist together. Every right has a corresponding duty attached to it. Just like how a coin is having two sides, just like that we have rights and duties. Take for example, if the state has given right to life to a citizen, it also constitutes corresponding duty. That is duty not to deprive others, right? Like we have laws under IPC, right? Like murder is a crime. Why? Because we are been given right to life. For us to be alive, other people are restricted, that you cannot simply go and kill a person. That is a crime, right? So if you are to enjoy right to life, all the other people will have a duty not to kill you or not to infringe this particular right, not to violate this particular right. Okay.
Yes.
Same ways, if we talk about right to free and compulsory primary education, 6 to 14 years in government schools, simply saying that kids between 6 to 14 years are having right to free education, that's not enough. Someone has to be there to provide the free education, right? So government has imposed the duty on education department, teachers of government school, administration of government school, inspector of school, all these different bodies, that you have a duty to provide free education to kids between 6 to 14 years. So whenever we talk about right, somebody or the other will be having some sort of duties attached to it. Thus, if a right which is recognized by the state is violated, then state also provides for a remedy. It's not that simply it's saying that, okay, you have this right, that right. That's not enough. Some remedy has to be provided, and that is explained with the help of this legal maxim, UB just EB Remedium, which means where there is a right, there is a remedy.
Okay.
And when we talk about right, it's nothing but a legal right. Law has given you a right. That means there is a remedy as well.
Remedy. Okay.
Now we have limitations of UB just EB Remedium. This maxim does not apply to moral and political wrong which are not actionable. If there is something which we say that, okay, it's morally wrong, it applies to legal rights only, right? It's not that morally something is correct or not. Like if there is a person who is owner of a bakery, okay, he's having a big bakery shop, there are a lot of some pastries, cookies, this, that stuff. If a beggar comes to him saying that I don't have money, but please give me something to eat, I'm very hungry. It is only a moral duty of that person to offer food for free. But he is not having a legal duty, right? If he is saying that, no, I can't provide you anything for free, there the person will not ask for a remedy.
Correct.
Okay, so it applies for legal rights only.
Okay.
This maxim is not applicable to those cases in which proper remedy is given in case of breach of right under. In cases in which proper remedy is given in case of breach of right under common law. So there are certain cases where you might be having, like some laws are not codified, like in case of torts, it's not codified. With the help of common law, like with the help of case laws coming in, with the help of different judicial precedents, things has come, right? So in such cases, we need to see what was the precedent, what has court recognized or what has this certain case law recognized, and based on that we look at the remedy. It might not be that it's written somewhere properly that this is a right, this is a remedy, but it's understood from the judgments, previous decisions that are existing for that. Okay. Precedent, you know, right?
Ma'am, the second point, this maxim is not applied to those cases in which proper remedy is given in case of breach of right of under common law. So, like
common law, common law as in something which is like judges play more active part. Okay, like in case of torts, okay, it's not somewhere written, it has developed with time, with different cases coming in. Okay, it is called as like common law. Okay, in England it has basically developed and we also adopted it. But in case of IPC, everything is properly written, right? This is a crime, this is the punishment. So in these cases, what happens is proper remedy is given in case of breach of right under common law. In common law, we have something established. There are cases, it talks about it. So based on those case laws, we will follow. It might not be properly written in the form of a statute like we have IPC and stuff like that. Okay, so common law is like, it's not how we have IPC.
Can you please give me any on at least imagination example for this, like how the previous point, how you gave the imagination explanation, like how
for example, there was one very famous case where like something called as mental shock. Okay, mental shock was not previously recognized as a kind of tort. Okay, mental shock was not previously recognized as a kind of tort. There was a case downtown, something name I forgot. It's there. I mentioned that on YouTube also. It's a very interesting case. What happened in that case? That was the first case which recognized this entire concept. Okay. One person came and he was just cracking a joke in front of a wife. Okay, so in front of somebody else's wife, he was cracking a joke that your husband met with an accident. He is there lying on the road helpless, and his, I think both the legs separated, something. Okay, very bad joke. And the wife came under such a shock, and he said that, okay, you need to take 2 pillows to support his leg, and he is like calling you, you should take a cab and just go there. She came under such a shock that her hair started falling, it started becoming gray. She had a lot of health issues and everything that followed. So as a result of that, this person was held liable. And mental shock for the first time was considered or recognized as a tort. Right? That means for mental shock also you get compensation. So how did this thing came? It came with the help of a case only, and now it's a well-recognized concept. It's included in tort syllabus also, but previously it was not there previous to that particular case.
Okay, ma'am.
So if there is no legal damage which can be caused to any person, then this maxim will not be applicable. So only when there is legal damage, there it applies. If there is no possibility of any legal damage being caused, nobody's right is being violated, this maxim is not going to apply. Only if there is a possibility that, okay, fine, someone's right may be violated, there only this remedy would be applicable. Okay, no remedies are available in case of breach of marriage vows or personal commitments, as these are the promises made without consideration and are based on trust. So in such cases also it's not applicable. But yes, there are personal laws where provisions are there to provide maintenance and all those stuff, right? But as such, we don't say that, okay, it is like a compensation for violation of a right, right? Parties are free to get separated, get divorced if they do not want to continue with a marriage, but we cannot say that it's like a compensation for the loss, but it's rather a way to support the spouse who is not financially independent even after the marriage. So it's not like a remedy that we have, remedy for divorce. It's not a remedy as such. It's just a support that is being offered by the court. Okay. This maxim is not applicable in case of public nuisance unless and until a plaintiff shows that he has suffered an injury more than members of the society. So these concepts we would actually be getting in other topics like nuisance. We have a concept. Public nuisance as in lot of, like maybe entire community or entire group of a society are suffering loss, like public is suffering trouble because of a nuisance. In such cases, if there are like 200 people who are suffering loss, you alone should not be going to the court saying, okay, my right is being violated. It's not just your right, it's actually right of the public. If you have suffered some extra or more harm, then that's a different matter. Otherwise, in case of public nuisance, usually one individual is not allowed. So that's also somewhere remedy might not be applicable because you have suffered the loss, but you have suffered along with a group of people.
Okay.
This maxim is not applicable where plaintiff is negligent or there is negligence on the part of plaintiff. You have suffered loss, agreed. The other person has done something wrong, agreed. But you also might have contributed, or maybe you were only someone who was doing wrong. Okay, you only entered somebody else's property without their permission. You suffered some injury there and you are filing a case. This person is not maintaining his property well. So court will ask you, why did you enter that person's property at the first place without being invited, without taking the consent, right? That means you only were doing something wrong. So in such cases also, you will not have a remedy. Okay.
Ma'am, if example, so like one person will enter, A will enter B place. So A is a, what is this called? Trespasses. Okay. So B will hit him. B will hit A, but A will go to court saying that but court will ask him, does court ask A, why did you enter his place?
See, it depends on what was the amount of force being used, because we have a concept of self-defense. Was that beating necessary? Was it with bare hand? Was it with a wooden stick? What was the level of force being used? So court would see all those factors. Okay, reasonable force you can use.
Okay.
Yeah.
So again, so many aspects will come under the picture, like as you said.
Yeah, all these different laws are like related to one another. Okay.
Another part of the law, yes, ma'am.
Yeah. So there are some ingredients that we have. Okay, first of all, we have there must be a right which is recognized by law. Your right is being violated and it should be a right which is recognized by law, legal right. Violation of such right, a right was given to you by law, that right was violated by someone which resulted in damage or loss, or maybe violation of that right is only enough. Okay, so first of all, a right which is recognized by law. Secondly, violation of that right. Thirdly, remedy should be for damages. Some damages or some compensation, some relief has been provided. The nature of the act varies from situation to situation. What did the person do? How was your right being violated? Those things depend on situation to situation. There may be a lot of different situations that might take place wherein a person's right is being violated. Okay, so court would see, were you given a legal right? Was your right being violated or not? Right, and because of that, what is the remedy available? Court would accordingly try to provide you that, like the best applicable remedy, court would try to provide you. Okay.
Provide me. Okay, ma'am.
So Ashby versus White we have already discussed. He was not allowed to vote. That means his right was being violated. Court gave him compensation. Him Singh versus State of Jammu and Kashmir. MLA was not allowed to take part in legislative assembly, so he was given compensation, right? Same ways we have these two more cases. We will see it.
Yes, ma'am.
Okay.
And in exam, how many cases I have to write, like for every?
That depends on your writing speed, marks in the question. A lot of factors are there.
Okay, so the more I write, there are chances of getting more marks, something like that.
Yeah, but then again, it should not happen that you are simply like writing one answer, and 2 hours gone, and you are skipping questions. So first preference should be answering all the questions. After that,
correct. Okay.
The content.
No. That is all about time management there. Okay.
Yeah. So next case we have is Mariti versus Williams. The defendant was the owner of a bank, and the plaintiff had an account in the same bank. The plaintiff had sufficient funds in his account, and when plaintiff went to the bank and he deposited a check, he wanted to honor a check. The defendant refused to honor the check to him. The court held that the defendant is liable for the loss caused to the plaintiff. The court applied UB just CB Remedium as the plaintiff has a legal right which was being violated. If a bank is there, bank is supposed to clear the check if there is no issues with the signature, amount or something like that. If the check is proper, you clear it. If something is incorrect, you mention that to the other person. You cannot decide that, okay, this person is having sufficient fund. What is sufficient fund, right? We cannot define that. It varies from person to person. So this person being the account holder in the bank, he has a right to ask to honor a check that he is having in his name, and bank should recognize or respect his right. If that is not being recognized, it's also nothing but violation of his right only. Okay. Then there was this case, D.K. Pasu versus State of West Bengal. Now, what happened in this case is it was not like I mentioned, right? Plaintiff is usually the one who suffers loss. There is a concept called public interest litigation, PIL, wherein someone else can also file a case. Like maybe I am a person, I have not suffered any loss. My right is not being violated, but I'm a person who is concerned about the society or rights of certain people. Okay. And I feel that maybe they are not going to the court, or maybe they have not realized their right. I can file a case on their behalf. It is called as public interest litigation. A litigation or a case filed in the interest of public. Okay. As such, my interest is not involved. Same happened here. D.K. Pasu versus State of West Bengal. Who was D.K. Pasu? Okay. He was working as executive chairman in an organization, Legal Aid Services in West Bengal, which is a non-political organization. And he came across this issue, okay, certain news which were being published regarding this custodial violence that take place. We come across these news quite often. So he also came across such news of custodial violence taking place. And he mentioned those articles published in Indian Express and Telegraph. And he wrote a letter to the Chief Justice of Supreme Court. And he said that this letter that I'm writing, it is to bring your notice to this certain concern. Please consider it as a public interest litigation. Chief Justice also considered that, yes, it is an important matter. It was considered as a public interest litigation, and Supreme Court issued 11 guidelines, which are followed till now. These guidelines are nothing but some sort of rights given to accused person. Once a case is filed against a person, he will also have some rights. If he is arrested, he will also have some rights. So these are mentioned over here. Okay, so that is also nothing but rights, right? You have a right to life and personal liberty, right to dignity and all that stuff. So if that right is being violated, you again have a relief or remedy. You can go to the court that I was not produced before the magistrate within 24 hours. I was not allowed to talk to my advocate in person, like like privately, I was not allowed to talk to my lawyer. All these are nothing but again your rights. If that is not recognized, you have a remedy for that. Okay.
Okay. Ma'am, previously we discussed one point now, ma'am, here under limitations of this UB just this thing. The point, the maxim is also not applicable in case of public nuisance unless and until plaintiff show that he suffered more injury than other number of people of the society. So example, I'll say I'm getting disturbed from this loudspeaker, something you imagine, okay? From any of the religion related thing, mic issue, I'm getting disturbed now. But in this case, I'm not only the person who is getting disturbed, my whole area is getting disturbed, but nobody is ready to raise the voice. But I will go to court. Then what happens? Court will not entertain my appeal, or how it is, ma'am?
Actually, there are again a lot of different provisions. We have public nuisance covered under IPC. You can go under there. Under CPC also, we have entirely different procedures mentioned. In some cases, it is being allowed. It's just a general rule that we have. Okay, there are again provisions where for public nuisance also you can go to the court and you can.
Okay, but that doesn't come under this tort, this one, right?
Yeah. Usually it falls under criminal law IPC, but under CPC also we have a provision relating to public nuisance cases can be filed. Okay.
Okay, ma'am. Okay. Yes, ma'am.
Yeah. So then you can write a conclusion that UBJCB remedium is very much important, because if someone is given a right, that's not enough. We need to make proper provisions that what if this right is being violated, like that. You can mention a conclusion. Okay, is it clear?
Yes, ma'am. Clear.
Okay.
Yes, ma'am.
So we have another concept called mental element in tort. Okay, we will continue with that in the next class.
Is it okay? Fine, ma'am. No problem.
Yeah, okay, fine then. Hey, before we continue, I wanted to inform you about my live mentorship program for LL.B students or law aspirants. Law subjects and law topics need detailed clarity. We get that with the help of cases, examples, and detailed explanation. It's definitely not possible to include everything in these short videos. If you find my videos easy to understand and you are looking for some professional help in preparing for your examination, you can join my live mentorship program. Here you will be getting exam tips, answer writing skills, detailed notes that you can refer for your examination, cases, examples, and in a very easy way topics will be explained. I have live classes going on for a lot of subjects as of now. To know more about it, you can drop me a message on this WhatsApp number. I'm also helping a lot of students in writing their assignments. If you need any such help or for any queries, any suggestions, you can drop me a message on this WhatsApp number. And now let's continue with our video.